Welcome to another edition of the Legal River Podcast, a weekly look at the laws and legal issues facing small to medium-sized businesses.
Hi, I'm Hyra. The name of my firm is Hyra IP, and I'll be talking a little bit today about patents and what the steps are for getting them. There are four main steps, and I'll cover two of them this week and the other two next week. So it'll be a two-part podcast. This part will cover the first step, which is getting patentability, search, and opinion, and the second step, which is choosing which type of application you want to file. The remaining steps will be covered next week. Step 3, which is preparing and filing your patent application, and Step 4, which is getting your application through the examination process at the patent office. So patents are rights that are granted by the government for new and non-obvious inventions. And what they do is allow you to stop anyone else from making, selling, or importing that invention within the country in which the patent was granted. But those patents are not granted automatically. You have to take some proactive action, you have to apply for the patent, and the patents are not enforced automatically. It's up to you to identify people who are violating your patent rights and to sue them to enforce your patent rights. So starting from the point of assuming that you have some invention and you're looking to protect it, what are the steps involved in getting a patent for that invention? Well, the first step is optional, but I recommend doing a patent search and opinion. And that's basically looking through what other people have done to see whether your invention really is new and not just a combination, an obvious combination of things that other people have done before. So you can start this off yourself, and I recommend that, looking in Google Patents. I think Google Patents is probably right now the best free patent search web-based utility. But even if your results from that search are positive, I do recommend following that up with a professional search and opinion, where someone who has a little more experience doing the search will go down to the patent office and actually use the same system used by the patent examiners and give you an opinion on whether you can get a patent and how broad of protection you can expect to get. And so once you have that, it allows you to make a little bit better decision whether maybe you should put it aside and save yourself the time and money of applying for a patent, or whether you want to go ahead and continue with a little bit more confidence. So the second step is to decide what type of patent application you want to file. And most likely what you want is a utility patent. Sometimes unscrupulous people will suggest a design patent, but a design patent only protects the appearance, the outward appearance of an object, and not what it does. So most likely that's not what you want. However, there are two types of applications that you can file if you want a utility application: a non-provisional application or a provisional application. And a non-provisional application is just a standard patent application. Once you file it, you can't add anything new to it without filing a whole new application. A provisional application is different. It's much less expensive to file, but it only lasts for 12 months. And at the end of the 12 months, it will expire unless you file a non-provisional application in the interim. So what would be the point of filing the provisional application first? Well, it gives you that year, if you need that year to further develop your invention or to find partners or investors or to market your invention. It saves that early date for you and gives you a year to do those things. And at the end of that year, you have the option of dropping it and not spending the money on the full application, if things are not working out. Or of course you can continue with the full application and actually add additional subject matter at that time if you further develop the invention. Thank you for listening to this week's podcast. Again, I'm Hyra, and the name of my firm is Hyra IP. You can reach my firm's website at hyraip.com. If you have any questions, you can reach me at the contact information provided on my website, or you can contact Legal River at podcasts@legalriver.com. Please stay tuned for next week's podcasts, when I'll finish up the last two steps for getting a patent.
Thanks for listening to this edition of the Legal River Podcast. If you have a business law question you would like to see answered in a podcast, please email us at podcast@legalriver.com. To reiterate, all views expressed in this presentation are intended only as a general discussion of the issues and should not be regarded as legal advice. For additional details or advice about a specific situation, please consult legal counsel directly.